Notwithstanding what I've heard from our mutual friends, I am gravely concerned in listening to your testimony, the degree to which you sound like you're still representing Donald Trump as his lawyer. Your criticism of the department, for example, filing a superseding indictment in the January 6th prosecution after a Supreme Court case so that the indictment would conform with that opinion, is the kind of objection I would expect to hear from a criminal defense lawyer, not the kind of statement I would expect to hear from a deputy attorney general. So let me just ask you, you have not been confirmed yet. Are you still Donald Trump's lawyer?
What's up, truth seekers? Today we're diving into the absolute chaos that unfolded when Adam Schiff decided to interrogate Trump's lawyer, who's been nominated for Deputy Attorney General. This hearing exposed everything wrong with Washington politics, and you won't believe how this Trump attorney handled Schiff's desperate attempts to trap him. The establishment is terrified of having someone loyal to the Constitution in the DOJ, and today I'm breaking down exactly why.
I mean, yes, my attorney-client relationship with President Trump remains. Yes, the cases I was representing him on, to the extent that there's anything going on like the appeal in Manhattan, I'm not part of that.
But you're still representing him as you sit here today.
Well, I mean, representing him, there's no active matters. So
correct, but you're still his lawyer.
I have an attorney-client relationship with President Trump.
And even if you're confirmed and you're no longer representing him as a criminal defendant, even then you still have continuing moral obligations as a member of the bar, legal obligations, to your former client, correct?
Like everybody at the Department of Justice with every one of their former clients.
Correct. So you'd have a continuing duty of loyalty and confidentiality when it comes to his communications, correct?
Yes.
Now, Ms. Bondi, as Attorney General, one of her first acts, established the Orwellian-sounding weaponization working group. In her memo, it says that the work of this weaponization group will be supported by the Office of the Deputy Attorney General, that is, the office that you will occupy. Would you agree that it would be a blatant conflict of interest as his criminal defense lawyer, as someone who has a continuing legal obligation to him as a former client, for you to participate in any of the work of that group as it pertains to the January 6th case that you represented him, or the Mar-a-Lago case where you represent him, or Alvin Bragg's office where you represent him? You would agree that that would be a very blatant conflict of interest?
I don't necessarily agree with that. There will be a conflict of interest potentially, but I quibble with the word blatant. And
okay. I mean, I take out the word blatant, but isn't it a clear conflict of interest? You've represented him in these cases. You acknowledge you still have a continuing obligation to him in these cases. How could you possibly oversee an investigation or review of the prosecutors in these cases when you handled them? How is that not the most obvious conflict of interest?
I am not saying I can or I cannot. I'm saying I'm not going to say to you today, Senator, yes, there's a blatant conflict of interest.
Well, why?
I don't know what the work is.
Well, can't you acknowledge that if you're asked to supervise cases involving your own cases, that would be a conflict of interest?
That's a very different hypothetical. Certainly.
No, it's not hypothetical. You're subject to the order of the Attorney General now to support that working group. That working group is going to look at the January 6 cases and the Mar-a-Lago case, the cases you worked on. So can you acknowledge it would be a conflict for you to oversee that work?
What I'm not acknowledging is the broad strokes you're giving it. That work, for example. There will be conflicts, and I will not violate my ethical obligations.
Well, let me just ask you with great specificity, will you recuse yourself from overseeing the January 6th case, the Mar-a-Lago case, and the Alvin Bragg case? Will you recuse yourself from the working group's supervision of those investigations?
I will follow the rules as told to me by the experts, career prosecutors in the department when it comes to every recusal.
I've heard that.
But it's true.
Well, it may be true in the abstract.
No, it's not abstract. It's true.
Well, here's the thing, Mr. Blanch, which you well know. You may very well get some opinion of an ethics lawyer appointed by the administration to tell you that you can exercise your discretion. If you believe it's a conflict, you can say you won't participate. If you don't, you can participate. So you may have discretion. So I'm asking you, how will you exercise that discretion? Will you recuse yourself from overseeing an investigation into matters where you are his lawyer? That shouldn't be hard.
You just gave a purely hypothetical, because the
this is not hypothetical. This is in black and white. It says, and I will read it, I hereby establish the weaponization working group, which will be led by the Office of the Attorney General and supported by the Office of the Deputy Attorney General. So this is what you're going to be asked to do. If you are given the discretion of overseeing cases in which you are his lawyer, will you recuse yourself?
It depends. The hypothetical you just described said that a career ethics attorney tells me I do not have to recuse for whatever reason. Because again, we are talking about hypotheticals. If the career Justice Department attorney says to me, you do not have to recuse yourself, I'm not going to sit here today and say that I will still say I will.
Okay, well, I mean, that answers my question. You don't think it's a conflict of interest sufficient that you would sitting here today, tell me that you were
said.
Yeah, no, I get it. I find it remarkable where we are.
Well, you're restating something I didn't say, Senator.
No, I find it remarkable that you feel there's any world in which you could somehow participate in an investigation of people where you represented the president in that same investigation.
I didn't say
Well, if you're not willing to commit to recusal, so that means you're willing to entertain supervising that work. So that tells me something. But let me move on, because I think you've made your position clear. Let me ask you very specifically about the Mar-a-Lago case. The Justice Department formally had recommended Volume 2 be made public. Do you support Volume 2 of the report being made public?
No.
Okay. Do you commit to preserving the evidence in both those investigations?
I commit for sure to following the law and following the rules.
But you won't commit to preserving the evidence. Let's say you have the discretion about destroying the evidence. Do you commit today to preserving the evidence in both those cases?
I commit to following the law.
Okay. And if you can't commit to preserving the evidence in those cases in which you were the defense lawyer, I think, again, that speaks to the conflict of interest that you have as the president's defense lawyer.
I did not commit to it. I said I would follow the law.
No,
I'm not sure. I'm not sure what.
Mr. Blanchard, I understand everybody's going to say generically they'll follow the law. But I've asked you a simple question about whether you will preserve evidence, and you can't say yes.
No.
You can't say yes.
I hope every single DOJ attorney, political, career, or anybody, would say they would follow the rules as it regards.
And I would hope that any DOJ attorney will say, I will always preserve evidence. There's no circumstance in which I will destroy evidence. That's what I would hope. Mr. Chairman, I yield back. Mr. Chairman, once again, we hear an effort to reinvent January 6th, this time as people expressing peacefully their disagreements with the government. January 6th was not a peaceful expression of differences with the government. It was a massive, violent attack on the Capitol with the object of overturning a free and fair election. Mr. Jordan cut off debate on my amendment to hold him in contempt, so we couldn't discuss what his role was, why he was subpoenaed, and whether he should be held to the same standard as a private citizen. And while he said quite erroneously that he was not required to testify, either because he took issue with the object of the investigation or because the speech and debate clause, as Representative Lofgren pointed out, that does not apply to subpoenaing a member of this body. Let's remember who did step forward, and let's ask ourselves not why he was compelled and refused, but why he didn't volunteer to come forward, why he was unwilling to share his information, why it was even necessary to subpoena him. After all, so many others did their constitutional duty. Republican Speaker in Arizona, Rusty Bowers, talked about how he was compelled by his oath, by his faith, by the Constitution, to do his constitutional duty, to refuse the former president's entreaties to overturn the election. And he showed his devotion to our country and the Constitution by coming and testifying. Jim Jordan would not. Brad Raffensperger, the Republican Secretary of State in Georgia, did his constitutional duty both to protect the vote in Georgia, to ignore the former president's demands that he find 11,780 votes that didn't exist, but also to come and testify, to share with the country what he knew, but not Jim Jordan. Cassidy Hutchinson, a staff member at the White House, showed extraordinary courage to come forward, showed her devotion to her country and Constitution, and came forward and testified, but not Jim Jordan. Capitol Police officers who were beaten and gouged that day, they came forward and testified, but not Jim Jordan.
He yields back. He yielded back. Oh, I'm sorry. Chair recognizes himself. I would just say this: why didn't they hold me in contempt?
I moved to hold you.
Why didn't the committee hold me? They certainly could have. It was a completely partisan.
Would the gentleman yield? And I'll explain why.
No. In a second, I want to finish my my time here. It was a completely partisan committee. Why not? I mean, the idea that if you could have held the future Speaker of the House, the future Chairman of the Judiciary Committee, the Freedom in contempt, why didn't you do it? I think they didn't do it because they knew it was bogus. They knew that the speech or debate clause would not allow them to compel someone member of Congress to come testify. But by the way, I never said I wouldn't testify. I wrote an 11-page letter to Chairman Thompson. I'm still waiting on a response, where I spelled out all the concerns we had with this committee, all the things we had caught them saying that were not accurate.
Will the gentleman yield?
No, it's my 5 minutes. I'll yield, and we'll have plenty of time. I'm sure there'll be a debate. They never made a record of it. We made a record of Hunter Biden not showing last week. We actually had a court reporter there. We made a record of him not showing up for his deposition when he was over doing a press conference on the Capitol, outside the Capitol. So I think the Democrats know how ridiculous that was. And with that, I would yield to the gentleman from California.
I think the chairman, my colleague, Mr. Swalwell, who participated in that contempt by asking for and holding that press conference for Hunter Biden, knows very well the history.
White House counsel, Republican White House counsel, came forward and testified, but not Jim Jordan. Unless we forget why the committee wanted Jim Jordan, let's look at our referral to the Ethics Committee over his failure to come forward for guide as to why we wanted his testimony. Representative Jordan was a significant player in President Trump's efforts, we wrote. He participated in numerous post-election meetings in which senior White House officials, Rudy Giuliani and others, discussed strategies for challenging the election. Chief among them claims that the election had been tainted by fraud. On January 2nd, 2021, Representative Jordan led a conference call in which he, President Trump, and other members of Congress discussed strategies for delaying the January 6th joint session. During that call, the group also discussed issuing social media posts encouraging President Trump's supporters to march to the Capitol on January 6th. An hour and a half later, President Trump and Representative Jordan spoke by phone for 18 minutes. Yes, we wanted him to come testify about what he discussed with President Trump for 18 minutes. And no, Jim Jordan has never told this body why he was unwilling to tell the country about that conversation in the run-up to a violent attack on the U.S. Capitol. Or why he spoke with White House staff about, as we wrote, the prospect of presidential pardons from members of Congress. He was unwilling to say why he thought pardons from members of Congress might be necessary. And today, he's unwilling to tell us why there should be a different standard for a member of Congress who is subpoenaed than for a private citizen, and why the standard for a private citizen should be so much higher. My colleagues on the other side of the aisle say that's not a germane question. We love to hide behind germaneness when we really don't want to answer the root of the matter. And the root of the matter is, why is Hunter Biden's failure to appear worthy of a criminal contempt, but the chairman of the Judiciary Committee's unwillingness to comply with a congressional subpoena gets nothing more than a shrug? That's really the question before this committee today. And so far, there is no answer. I yield back.
Schiff went after Trump's lawyer, trying to paint him as some kind of Trump loyalist who can't be trusted at the DOJ. Classic Schiff playbook. If you can't attack the argument, attack the person. The nominee admitted he still has an attorney-client relationship with Trump, and why wouldn't he? That's how the legal profession works. But Schiff tried to make this sound sinister, as if having represented the former president makes you unable to enforce the law fairly. What Schiff really wanted was for this nominee to throw Trump under the bus to get confirmed. But this lawyer wasn't having any of it. He stood his ground while Schiff tried increasingly desperate tactics to get him to say something, anything, that could be used against Trump later. Schiff's next move was predictable but still outrageous. He focused on a so-called weaponization working group that would be supported by the Deputy AG's office. Basically, he was setting up a purity test. Will you promise not to investigate the investigators who went after Trump? The nominee refused to play this game. When pressed about recusing himself from overseeing cases where he represented Trump, January 6th, Mar-a-Lago, the Manhattan case, he didn't take the bait. Instead, he committed to following the rules and consulting ethics experts. This drove Schiff absolutely insane. He wanted a blanket recusal promise that would cripple this nominee's ability to address the political weaponization of our justice system. The nominee's refusal to make that promise shows exactly why the establishment fears him. Then came perhaps the most telling moment. Schiff asked if the nominee would commit to preserving evidence in cases where he was Trump's lawyer. This was a pure gotcha question designed to make headlines either way. If he said yes, Schiff would claim he admitted to conflicts of interest. If he said no, headlines would scream, Trump's lawyer refuses to preserve evidence. Instead, the nominee simply committed to following the law, a perfectly reasonable answer that left Schiff visibly frustrated. What we witnessed was a masterclass in not letting political operatives like Schiff dictate the terms of engagement. This nominee understands exactly what's at stake in our justice system. Hey, if you're enjoying this breakdown of Washington's corruption, smash that subscribe button right now. I expose these political games daily, and trust me, you don't want to miss what's coming next. The hearing then shifted to Jim Jordan and the January 6th committee's double standards. Democrats characterized January 6th as a violent attack while conveniently ignoring years of leftist riots. They're still obsessed with a phone call between Jordan and Trump on January 2nd, 2021. But here's the real kicker. They're outraged that Jordan wasn't held in contempt for refusing their partisan subpoena, while they're perfectly fine holding Hunter Biden in contempt. The hypocrisy is off the charts. One set of rules for Democrats, another for Republicans. Jordan rightly pointed out that the committee was completely partisan from a start. He even wrote an 11-page letter to the chairman outlining his concerns that was completely ignored. This hearing perfectly demonstrates why Americans have lost faith in our institutions. We witnessed a Trump-nominated lawyer refuse to bow to political pressure, maintain his principles, and expose the games being played by Adam Schiff and his allies. The nominee understands exactly what's been happening. Our justice system has been weaponized against political opponents. By refusing to make promises that would handicap his ability to investigate this corruption, he showed exactly why he's the right person for the job. The establishment doesn't want equal application of the law. They want selective enforcement that protects their friends and targets their enemies. This hearing made that crystal clear. Remember this the next time someone tells you there's no deep state. That's all for today's breakdown. If you found this analysis valuable, hit that like button, subscribe, and share this with someone who needs to see it. Until next time, keep fighting for truth.